It is 10 o'clock. Here I am. We are opening the hearing on all of the retained bills, the bail commission bills, and we are going to be going into a recess so that our members can caucus, considering how much we discussed yesterday with the ranking members. So we will be in recess till about 10:15 or later.
Rise and join me for the Pledge of Allegiance. Shall we begin? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, we are picking up again on our continued hearings on the retained bail bills. And today we're going to be addressing the subject of people who are arrested while they are already on bail for a previous crime. We have several proposals that we've been working on that we're going to discuss right now. The first proposal with regard to someone who's arrested while on bail for a previous charge. What we've looked at, based on all the testimony we received, first of all, that the public in general is had enough of people being arrested in this type of a revolving door type of situation happening. And it's not necessarily the very serious crimes as were contemplated in several of the bills we had, like a list of 12 or 13 crimes. These are the more, for lack of a better term, nuisance crimes, the shoplifting, the trespassing, the disorderly person repeatedly. So what we are contemplating is, if you are arrested while on bail for the first time you are picked up, we are talking about having the court system, through the bail commissioners, give the person a choice. Here's your choice. You've been arrested and violated the terms of your first bail, which is a new crime, contempt of court. You may be released if you so choose, but as a condition of that release, you will wear an electronic monitor, which will be placed on by the bail commissioner, and he will or she will set the conditions of that bail and what that electronic monitoring system will be monitoring with regard to your specific situation. Or B, you can decline the electronic monitoring and you will remain in jail until you see a judge. Second offense, if you get picked up yet again while wearing the monitor after you've been released again, you will be held until you see the judge. Now, as part of that, we are cognizant of the court's ability and the Defense Department's ability to be able to conduct business on Saturdays. At some point in the future, that may be something we have to look at. Currently, with the time frame, money, and resources available to everybody involved, it's just not feasible. So as part of that, and we'll be discussing this next week more in depth, we're looking at implementing a magistrate program where magistrates will, and I brought this up briefly yesterday, be assigned to each county in the state, and they'll have first line supervisory over the how many bail commissioners are in their counties, etc. They'll probably coordinate the issuance of these electronic monitoring devices, and the whole program will be left up to the court. That's their business. We're not going to micromanage it. But as far as the weekends, which is what I want to address, if you're picked up on a Friday for one of these things, you will be held up to 24 hours, at which point you will see a magistrate over the weekend on a Saturday who will make the determination whether or not you're dangerous, flight risk, or you should be held. They are going to be no different than the than the bail commissioner. They're not going to have any more powers than the bail commissioner with regard to the bail. So it's not going to invoke all the necessary hearings and everything of this nature. It just means that you're going to be held for this person who will be probably a JD, someone more qualified than the average bail commissioner is. Again, that'll be set in the legislation that we discuss next week. So for today, that is what we are proposing with regard to the arrest and rearrest while on bail, and I would open it up to discussion from the members. Representative Stone.
Thank you. In regards to the term magistrate, have you set a definition of a magistrate? Is it going to be someone who has to be admitted to the New Hampshire bar?
We have not yet set that definition, but that is one of the things that we are working on as far as what the qualifications would have to be.
Thank you.
And I would welcome your input because we're at that stage where we're trying to figure out what that is. But with anything with regard to the rest and rearrest, Representative Muse.
I think one of the dilemmas facing us is with issues like this, there are so many factors that come into play. Essentially, I think we're in a situation where I think we can substantially reduce the risk, of the public being harmed by a person who's out on bail who should not be. On the other hand, I don't think we're ever going to be in a situation where we can 100% guarantee, uh, you know, uh, uh, that all of us will be safe. So I think there are reasonable measures, and I think this is one of them. Electronic monitoring as an option uh, is something that will provide more guardrails. And it's an alternative to incarceration. It's, however, not without its problems. And I think there are issues that we're going to have to work through in terms of the cost, who does the monitoring, how exactly bail commissioners are, implement this and are trained to do it. Um, but the bottom line is what it does is it does put more accountability in the system. It puts more oversight into the system. It's something that the public seems to be asking for, and it is um, one of the. It's a less restrictive option than simply holding people in jail pretrial detention, and it puts people in a situation where even if they've committed a second crime, a lot of times those second crimes are still relatively minor. And even though people have been accused of crimes and sometimes even accused of two crimes, we're not always there. Frequently there are situations where people are actually in the end convicted of neither crime. So having an additional tool in the toolbox, to better ensure that people, that people do appear, um, to me seems like something that is worth exploring more and potentially trying.
Thank you. And to add on to that point, it will be significant. There is going to be cost, and there is going to be a fiscal note, but I dare say it will be much less than holding people would cost if they're arrested on the first time after they've been bailed, because that will drive up exponentially the number of people who are held, and the cost will be very, very high. So I feel like this will be a lower cost to the state and the counties. Actually, it shouldn't be any cost to the counties, where the counties would bear the full cost of people being held. And we heard from the counties that they just don't have the finances or the wherewithal to be able to staff that type of a increase. So and also keeping in mind, this is a choice. We're offering people a choice. They don't have to take electronic monitoring. If they feel it violates their privacy or their rights, they're free to sit and wait for the judge to hear their case. Representative Stone.
Thank you. Is there going to be a recovery cost for the individual if convicted?
We're not sure yet because we don't know the cost, what it's going to cost at this point. We could leave it open to the court whether or not they assign a fine or some type of recovery for the cost of the expense of the monitoring. The difference, the difference is it's pre-conviction. So I think it's difficult, even if they do end up being ultimately convicted, I don't know that it'll be difficult to recover that amount. I don't know. We can discuss that with the court and see if that's something they're interested in.
Thank you.
Yeah, definitely worth raising. Representative Murray.
I was thinking along the same vein. Like, I know the folks who came to talk with us from pretrial services and stuff talked about how they would charge the people that were being monitored for the cost of monitoring them daily. But I don't know if it's better to do it as a recovery if they're, convicted, but those were pre-trial.
Representative Stone.
Just to a follow-up to that, since the probation and parole department already utilize electronic monitoring, and I believe there is a service fee for them being out on release, I guess that's an avenue that's already been set. That's why I'm looking at due process is served and the conviction is had, then maybe there is a recovery mechanism that could help offset the cost of the taxpayers.
I agree. I agree. Within the usual parameters of indigency or whatever, if the person is able to repay, then they should, and we'll leave it up to the courts about how they would like to reclaim that money, I think. Representative Muse?
And one of the things that we've run into as we've done some research on this is there are alternatives to things like electronic ankle bracelets. So there are apps that some jurisdictions are using. One of the things that we've learned during testimony in the various work sessions that we have is that surprisingly there are a lot of people, even homeless folks, who have cell phones. Whether or not these apps, will work on the particular phones that people have is another question. But increasingly, there appear to be options in addition to just conventional ankle bracelets. So as we write the statute, one of the things that we've talked about doing is actually writing it in a way that describes the functionality of the monitoring device without necessarily specifying which monitoring device is acceptable.
I think actually that's a very good point, and we are going to as broadly define electronic monitoring as possible so that we don't have to come back and broaden it later as technology gets advances faster and faster. We want to describe what we're trying to accomplish with the electronic monitoring and leave it to the court to decide which method of technology they use going forward, so that if such a time comes when they're able to use a different technology, maybe software or what have you, or a combination of any of them, they have the bandwidth or the allowance in the legislation to do that. So I think that's a very good point. Further discussion, anyone else? Representative Harry Gathright.
We also talked a little bit about on the first arrest, if we realize that that person is, let's say, doing drugs or mentally ill, at that time trying to refer them for some type of help with whatever's determined at that time.
Yes, we did discuss that, and we are going to put that in. What we're contemplating is, so when someone is first arrested, regardless of the crime, there are services generally available. So, for example, if someone is arrested for shoplifting because they say, I have to have food for my family, the state is not without a heart. So what we are going to do is ensure that that person gets referred to services where they could get food. So that if they're picked up again for shoplifting for food after they've been given a referral for services, we know, okay, you had a chance to get that and you were offered that. So we're going to mandate that services be referred on first arrest for anything that is related tangentially to the crime they're arrested for. If they're arrested for drugs, referral to rehabilitation services or what have you. Same thing goes for food, anything like that, where there are services available to make sure that the people are connected with them as soon as possible. Did that cover that, Linda?
Yes.
Anyone else? Representative Reed, you seem to have some reservations.
If they're referred for services, will they still be, have to see the judge and okay.
This is just here you are, you're under arrest, here's your bail, and
Okay.
by the way, here.
All right. So
It's not in
they'll
place of
still-
or lieu of or
okay.
anything like that. It's just making sure that people are made aware of services that are available.
All right. Thank you.
Oftentimes, I think what happens now, some of the bail commissioners are very good at saying, okay, look, you could go here, but some of them may not, some of them may not know. And so oftentimes people are arrested and let go, and they're just right back where they were with no idea how to contact services. So we're going to mandate that people are at least given referrals to services that are available.
I see. Thank you.
I do have another question, but I think I need the officer to answer this for me.
Sure, if he's willing to
Are
testify.
you willing to?
I saw your hand, Professor Scher.
Yeah. Good morning. So Goffstown, so are you that would be Hillsborough County, right? Okay, question for you. Okay, do you say as Goffstown, do you know the different services that might be in the area as a police officer?
I guess it's kind of a broad
Okay, let's say someone that has mental illness, do you know where you might be able to refer that person? Or
Ye-
if someone seems to be on drugs or alcohol, do you know where? You
Yeah,
might-
we have the mobile crisis team, which is out of Greater Manchester Mental Health.
Okay.
So we know that we have connections with them.
All right, that was one of the questions that we had because we realized that Hillsborough doesn't have the pre-service type accountability as some of the other locations that came and spoke before us. The other counties came and they
Correct.
have
Like
a lot of-
Rockingham has a
yeah,
pretty
they have
decent
great
pretrial.
services.
Hillsborough does not.
Exactly, but for the most part, the officers do know of the different types of services possibly.
Yeah, we often deal with the mobile crisis team with Greater Manchester Mental Health for mental health issues.
Okay. So
And I think we're not contemplating putting that on the police anyway. I think we're gonna put that on the courts to make sure that the people are notified of the services in the area, versus the police, I think.
we talked about on first arrest.
Yeah, but they still have to get bailed, so a bail commissioner could,
We-
through the court,
Right.
provide whatever documentation the court gives them to hand out for that area, because I don't want to put that funding cost to produce all that information on the police departments, if we're going to pay the courts anyway. Any
Okay.
other questions for the officer? Representative Stone, please.
Thank you. In your experience, do you find that these proposals would meet the needs to try to address the nuisance arrests that maybe your department or similar departments experience
The electronic monitoring specifically.
as part of the bill process?
I mean, it's something. Right now they're just walking out of the PD. They're walking right out the door. Domestic violence specifically, they're just getting PR bail and walking out. I prosecute also. I'm an attorney. I prosecute for the PD, and the amount of failure to appears at court are through the roof, and it's just wasting time.
And if they were on the monitor, you'd know right where to go pick them up if they failed to appear.
Do
Is
it. Yeah, I got a stack of failure to appears every court appearance I'm in.
Yeah. And I believe that as part of the monitoring, we're going to, as we write it, we'll leave it open for software or whatever. Even perhaps through the monitor, they can be buzzed to notify your courts coming up. I mean, there's all kinds of technology. So we want to make sure that we know where they are if they're not supposed to be somewhere. So if you have a defendant who's been arrested for trespassing at a store and part of his bail conditions are not to go back to that store, you'll know through the monitoring that he's back at that store and yet again violated his bail conditions, and you'll know right where they are to go pick them up. So do you feel like that is a step in the right direction towards helping?
Yeah, I do, and I think specifically on the, I go back to the domestic violence
Yeah.
again, where there's a no contact order. I think that will have some protection for the victim if that defendant is out there, because they're oftentimes in violation of that no contact order, and the victim may be afraid to call the police because he or she doesn't know what's going to happen, going to set him off or her off again.
Right. So the monitoring would notify law enforcement that the person is again within the geofenced area, that they're not supposed to be near that victim.
I'm not too versed on how these bracelets work and how the police would have access to them, but
Yeah, well, the court, what we're contemplating is that the court would have to enter a contract with the company that monitors, and the monitoring agency would notify whoever the court tells them to notify. So if the court says, as part of your bail conditions, you are not to go within 1,000 feet of this person's residence, or the police will be notified, that company would then notify the local police that that person had indeed violated the conditions of that release.
Yeah, that would be excellent.
So with regard to further Representative Stone's question to you, and as far as being arrested and held, if you are arrested yet again after on bail, do you feel like that is a beneficial proposal?
I do. And, you know, for a couple of reasons is, you know, the safety of the public and for the assuring they're going to show up in court. If they're out on bail and still committing more crimes, likely they're not going to show up for court either.
Agreed. Okay. Any further questions for the officer? Thank you, Captain. Professor Scheer, you had raised your hand. Oh, I'm sorry. What? Representative Murray, did you have a question for the officer?
No, not a question. Thank you. I just feel like I have to name that we heard a lot during testimony about the lack of services available. So, even though we're going to require bail commissioners to, inform people about available services, there might not be like services available to refer people to.
Representative Rhodes.
Thank you, Mr. Chairman. In reference to Representative Murray's comment, we heard from a few of the counties that do already have these pretrial services. And one of the things that I mentioned, and I realize that I'm preaching to the choir with all of you, but I would just like to stress to everybody here, if your county does not have these pretrial services, you are in a very, very unique situation to approach your county commissioners and get the conversation started. If it's happening in other counties, it can happen in all 10. And we have to be the ones to make it happen. And if you need to reach out to the other counties to have them come to your county, I guarantee you Cheshire County would do that. And that's going to be on all of us to make that become a reality.
Also, I think that as we discussed, one of the bills that we are going to repurpose to task the existing interbranch commission that worked on bail in 2018. That commission still exists, and we're going to retask that commission to come up with legislation and ideas to institute statewide pretrial services as one of their mandates. So that issue is not going to go away when we're done with this. Professor Scheer.
A couple points about what you've all been talking about, and I appreciate the committee's efforts to sort through this in a way that is productive. Just briefly on the services issue, I think in terms of how that recommendation is drafted and put in the legislation, I counsel very strongly against putting the burden on a individual, on a defendant, to get services when, depending on the area, it may be very, very uncertain whether those services are available. So I don't want to say to an individual, you need to go get these services, and because they're in X county, those services
If I
are
may,
available.
the recommendation was going to be specific. In other words, XYZ NGO is available for you to go talk to, and it won't be just go find some services.
And in terms of services, as Representative Rhodes knows well, pretrial services programs are funded by the county, and I know Cheshire and Stratford County have more money because they're housing federal inmates, and I think that makes it very helpful for them. Whereas, Coas County and Carroll County are in different circumstance. In terms of electronic monitoring, I'm of two minds. One, I think giving electronic monitors to everyone could be overbroad. I mean, there's just some crimes just not going to make any difference. The crime doesn't relate to trying to understand where they are. That said, I understand the dynamic that the committee has laid out, and it allows for somebody to be released, and so I get that. That one of the two key things that I think are really important, while if somebody is found, if the third party agency for whom the court contracts learns that a person has violated the strictures of the electronic money. They've gone somewhere they shouldn't have gone, or whatever, or they haven't showed up for court, and they notify the court, and the police, the court notifies the police to go pick that person up. I think it needs to be explicit in the legislation that the police do not have access to all the electronic monitoring data on that person from the time the monitor was in place to the time they were picked up. I don't think we should create a circumstance where the electronic monitoring system is used as another investigative tool for the police. I think it needs to be narrowly written so that the only information the police get from the third party via the court is where this person is now. And that's all they have access to. They don't get to look at all the data and figure out where, other things, use it for investigative purposes. I think that's very important.
Let me just address that before you move to the next point. I think that does raise a good point. I think that whatever in the statute, it will say that the court will authorize the information to the police department for violations of the terms of bail. In other words, if the term of bail is you don't go here and you go here, that information can be relayed to the police department. But the blanket, where this person is all day long will not. That's why we're not having the police monitor it. We're using a third party. I do believe, however, that if a proper warrant is obtained, it should be made available if a search warrant is authorized.
And therein, that's a difficult situation. I have difficulty with that, to be honest with you.
We're not going to put it in the thing, but I imagine it'll get raised at some point in the future. In the future.
Second, I think it's a big mistake to create a circumstance, any circumstance in which the individual upon whom the electronic monitoring is placed pays at the time after the fact. People the large majority of people involved in the criminal justice system don't have money. As I've said in all sorts of different contexts, they don't even have the luxury of living paycheck to paycheck. And, every little bit is a problem. For example, the court coming after them for bail commissioners' fees, the penalty assessment that's used to fund certain things. There's all sorts of fees put aside getting fined, put aside if you're convicted having to reimburse the state at a certain rate for the counsel that you got because you're poor, and now you have to reimburse the state. There's all sorts of these fees separate from fines and restitution that pile up. And I just, I don't like the idea that we're just adding another fee. $50 for everybody on this committee is a lot different than $50 for a homeless person. And I don't think they should be punished for having electronic monitor.
We will take that under advisement. I would differ a little bit. I think that if they have the wherewithal to pay, they should be made to pay. If they're indigent, they should not. We shouldn't automatically put it on the taxpayer, who also is being buried in taxes and fees on a daily basis as well and committed no crime. So, but I do take your point, and I think indigent people obviously will say if you're indigent, you're indigent, and you cannot get blood from a stone. So, but if someone does have the wherewithal to pay, I do not see why the taxpayer shouldn't get reimbursed.
And I understand the chair's perspective, understanding that the court system will say, great, thanks. Another time, I've got to figure out whether this person has the ability to pay or not.
Could that not be done as part of their determination of whether or not they get counsel?
In theory.
I think I'm going to leave it that it's broad enough for the court to make the decision. If they are already doing a determination of indigency for whether or not they can get counsel, I think at the same time that can say, well, if you can't afford counsel, you can't afford monitoring, and
Yeah,
no, go on.
the difficulty there is, to be blunt, the huge majority of judges say, well, not being able to afford counsel, not being able to afford $5,000 or $1,000 for a counsel or $10,000 is different than not being able to afford $50. I think every judge that I've talked to will say everybody can afford $50. You know, that's my problem, and it's the accumulation of $50 amounts that do some people in.
What if we specifically tie it to eligibility for counsel? If you are determined to be eligible for public counsel, you are also determined not to be required to reimburse for the.
I'd feel a lot better about that.
Thank you.
Representative Stone is waving his hand. I don't think he's just waving at me.
I think he may.
Just for clarification, would the first time individual being bailed be an automatic requirement for the electronic monitoring, or would it be optional?
It's optional. They
Okay.
can stay in jail if they want. That's
I
their
just wanted
choice.
to clarify that.
Yeah, yeah.
My understanding was the electronic monitoring, was that the first time somebody is arrested?
But it's their choice.
That's not true.
But no. It's the first time arrested while on bail for another
Okay.
offense. Yeah, yeah.
That's what I understood.
I don't think we have the money to put it on everybody. But no, the first arrest while on bail, they have an option: take the monitoring or stay with us. And the next time, that option's not available.
I think this is my last point. Pick up on something Representative Muse was talking about. You know, I think some on the committee know there's been some very valuable studies done, at least a couple done, about having a system set up where you can text individuals that their court date is coming up.
Yeah.
There's really good research that's been done, and the court system did a pilot program out in Rochester that they got some good results from, and then the pandemic hit, and they had to unwind it, and they still want to do it, but they don't have the money to do it. I would love to, as the companies are being investigated, or the means of doing electronic monitoring is investigated, you know, I think it would be very, very helpful if there was a requirement that they had an ability to notify the individual who has the electronic monitor that their court date's coming up. It's like a twofer. You know, you reduce failures to appear, and you have the other benefits that the committee is looking for electronic monitoring.
I agree, and we are going to put that in there. That's why I want to craft the definition of electronic monitoring so broadly that the court can use and request funding for any type of technology that it appears that's successful to help ensure people's appearance and their good behavior. Thank you. You lied, didn't you?
I did lie, but, well, I didn't lie. I'm a law professor, so I have the right to go on forever.
He made it funny.
You did.
A reference to mobile crisis units. I'm
Yes.
very familiar with mobile crisis units because we've been working very closely in Portsmouth. The police commission, of which I'm a member, has been working very closely with Seacoast Mental Health and members of the police department and others to facilitate the use of the Seacoast Mental Health, Seacoast Mobile Crisis Unit. What they're for is they're not really for somebody's in court and the judge can refer them to the mobile crisis unit. What they're for is, to be way too cute, they're for crises.
Yeah.
That is, either the mobile crisis unit or the dispatcher for the police department gets a call saying, from, say, a family member that my spouse seems to be in a mental health crisis. There'll be an initial back and forth questioning of the person calling in to determine whether there is a realistic possibility of danger to anyone, whether weapons are involved or anything like that. If not, then in the first instance, the dispatcher will will contact the mobile crisis unit to go to that location, which involves mental health professionals. It doesn't involve uniformed police officers showing up.
So the point is that they're not a service that you refer.
They're not a service that the court can refer people to.
Gotcha. I think that it'll behoove the court to put out the word that if you would like to have your services offered to defendants, please let us know, and we will populate a sheet of people who can be contacted.
And I think that'll be an excellent exercise with the courts.
Excellent. Thank you. Representative Muse?
As we write the legislation, one of the things that may be important is making sure that we put some guardrails around the use of the electronic monitoring data. And the reason that I say that is that because in Massachusetts, there's actually already been a case where the Supreme Court there has ruled that essentially what the case involved was the police looking at monitoring data across a large number of people who had monitoring bracelets to see if any of the people being monitored were in the vicinity of a robbery that took place. As it turns out, yes, one of them was in the vicinity and was arrested, and they actually disallowed that particular arrest. And the reason they said is that going forward, the Commonwealth has to demonstrate on the particular facts of each individual case that warrantless monitoring is reasonable to justify the attachment of a GPS ankle bracelet. So one of the things that, you know, one of the things I think that we need to consider is in this state we have a court system that's especially I think that probably guards privacy rights maybe even more carefully than Massachusetts does. And it's just something I think that we need to be aware of as we put this together, that that establishing a blanket requirement may get us into legal and constitutional issues down the road. I don't know. What would your opinion be on that?
You're going to get me going again, but I apologize, Representative Rhodes. In 2018, the New Hampshire legislature and the voting public passed a new constitutional amendment that said an individual's right to be free from an individual's right to be free from governmental intrusion on personal and private information is natural, essential, and inherent. That is basically an information privacy constitutional amendment. Massachusetts doesn't even have that, and that opinion came out that way. It's a new constitutional amendment that is still early, and courts haven't been interpreting it, but having been the author of that constitutional amendment, I think it's a very expansive language, and it's going to protect privacy rights in New Hampshire as to personal or private information more than any other state does. I mean, there's no other state that has that. So I think, the electronic monitoring issue and police having access even through a search warrant to that data is going to be a big issue. And
I don't intend to write that they can have access to a search warrant. I anticipate at some point someone is going to apply for a search warrant and try to get it, and we will leave it up to the courts to interpret the constitutionality of that in light of the new amendment. So I think that they need to tell us what they think of it. But as far as letting that information, Representative Musin, your point is well taken, and I don't anticipate allowing broad access. I think only notifications will be violations of bail conditions that were set, and that should suffice for what remember, we have to keep in mind what our goal is, to ensure that someone complies with the conditions of their bail, since they apparently didn't, to be arrested yet again. So the only information that should be shared is when there is a violation of the bail, and specifically that information only. And it's not mandated. They do have the choice to say, I don't want it, and stay in jail.
And I would specifically ask that in the legislation in that regard, the only information being shared is the location of the violation rather than broadly, anything more broad than
Oh,
that.
yeah. I couldn't see, there'd be no probative value in giving them the whole day's worth. All they need to know is when the violation occurred and where.
Yep.
Agreed. Representative Pratt.
We went over texting the person that a court date is occurring. I've never been arrested, so I don't know. Do they get a letter that says they have a court date?
They are
No?
in the better courts. They are told when their court date is. Depending on a lot of people don't hear that given the stress that they're under in that circumstance. And I believe I'm not the best person to talk to, but I believe they are provided with a letter. But there's some people who don't have an address at which they pick up mail.
Okay, I'd be in favor of the text in addition to a letter, but not in place of a letter.
Yeah.
And the second part of my question is, wouldn't a test for indigency be they can afford a phone and service? I know people that work for a living that can't afford a phone, but they're not indigent.
Let me just answer that if I could. The federal government now gives away phones.
Yeah.
I don't know that your friends would qualify because they do work. So
Thank you.
that's a bigger discussion for another body, I think. But yeah, they all have phones. And if they don't, it's probably because they need other services because they are not aware of the fact that the government is giving away phones.
I was not aware that the government.
Oh yeah, yeah, they do. Any further? No, thank you. Okay. Oh, yeah. I'm sorry. Did you have? Oh, hello. Did you want to say something? Absolutely. Please make space.
Good morning.
Good morning.
I'm Sarah Rothman. I'm the Executive Director of the New Hampshire Public Defender. I just wanted to make two short points. One is, I don't hear that this is being said today, but moving forward, with regard to electronic monitoring, sometimes as these programs evolve, it requires the defendant to have an address, that you won't qualify for electronic monitoring unless you have a home address. And so I would like to urge the committee not to adopt any legislation that would exclude probably the very people that we're trying to capture.
Good point.
The people who struggle with homelessness, maybe not a lot of them full on homelessness, but some of them just transients, staying here for a few weeks and there for a few weeks. And so I just don't want to go down that slippery slope that we often see with electronic monitoring, that the very people who would benefit most for it end up not qualifying for it. The other point I wanted to make is to urge the committee to consider, in terms of the sort of outline that you've presented with, if the first time you are arrested while out on bail, you get this choice for electronic monitoring or hold. I would urge the committee to consider kind of saying that is for if you're rearrested for, a felony offense, to kind of craft it more specifically than just any offense while you're out on bail. And potentially if there are, misdemeanor level offenses, particularly domestic violence related offenses that you did want to enumerate, that you be more specific than just kind of any arrest while you're out on bail. because the volume, and I know kind of herein lies the point, right? Like that this is a large volume of people, and that is what the committee is hoping to address.
Yeah.
So I am cognizant of that, but at the same time, it's a large volume of people that you are talking about. Like it is a large volume of people. And I think as Professor Schur has indicated, not all of those people, even law enforcement would agree, would benefit from electronic monitoring. And so as you draft legislation, I would urge you to consider, being specific about what level of offense or what categories of offenses this would trigger.
And to your point, herein lies the problem. The reason we're actually here, in my opinion, more so than all these serious crimes, is these repetitive crimes that are low level,
Yep.
trespass, shoplift. And if we say, okay, only felonies, they're going to keep walking out the door. And at some point, and maybe more than anything, we're trying to force the court to address this and say, fix this. We cannot just keep turning these people loose to come back before you. The police departments aren't goalies just kicking people back into play. We have to find a way to address it. And as much as I would like to narrow it, and I will contemplate and take your testimony under advisement, we're struggling with a way to do that, which still does what the public is demanding we do. We're kind of caught between a rock and a hard place. But we're still thinking, and if you
Sure.
have ideas,
Yep.
I'm happy to hear them. Representative Reed.
Thank you. Just basically a comment. We were on the adult parole board study committee, and they found that, the high utilizers were the ones that were 2.5 times more likely to be booked for infractions, and 5 or more entrances on average, beside the non-high utilizers. So I think this would really impact the people we're trying to reach the most. So.
I think at the end of the day, and I can speak for just about everyone in here, the problem is the lack of resources that address what is causing these people to offend. And the only way we're going to get there is to take a step in one direction. And we're going to revitalize that study commission and mandate that they find an answer to that, be it statewide pretrial, something, so that we can intervene before these patterns of arrest keep continuing. Anything else? Any questions?
Just briefly, kind of on that point, in terms of creating a flyer of sorts to be
Yeah.
handed out by bail commissioners, the public defender is more than happy to be involved in that process. We have social workers on staff who already have those kinds of materials, that we give to our clients, and so we're happy to share and collaborate on that.
Excellent. Thank you. Thank you. We will look at putting that in there, that there's a coordination between various entities. Representative Rhodes.
Thank you, Mr. Chairman. This is probably not going to be a very popular thing, and I apologize up front, but listen, we are not going to be able to make everybody happy. I don't agree with my husband 100% of the time. And I think what we have to realize is, if you are rearrested while you're already on bail, that itself is a crime. And we're trying really hard to keep people out of jail, but we can't want to keep people out of jail more than they want to be kept out of jail. And, there's a difference between an excuse and a reason. And there has to be some accountability, right? And we as a society are taking a lot of accountability with all the programs that we're trying to do, with coming up with this, this option other than incarceration. And we can't fix every social problem, right? These are things that are starting in the home, and here we are trying to deal with it. So I think everybody, what I would like is everybody to take a step back and realize we're not all going to be happy. And what we've come up with in this committee is more than anything anybody else has. And I think we just all need to focus on that.
Thank you. I think it's worth noting that's very accurate. But at the same time, people in this room know that there's two societies, And most people don't realize it, but there are two societies. There's us, who are here functioning and rational, and we plan vacations and we plan for our retirement. And there's another society within our society that lives minute to minute, day to day, meal to meal, and they just don't have the ability or capability to understand and make those kind of decisions. So when you and I are faced with a choice of should I do this or should I not, we think out the ramifications, whereas they think, well, I'll still get the meal and I'll deal with that later. So I think that we have to always keep in mind that not everyone operates in the same plane of responsibility as they should.
Just to
Rep-
oh, sorry, go ahead.
Representative Murray.
I definitely agree. We're not going to come up with something that everybody's going to be 100% on. And I think we're doing a good job compromising so far. And I appreciate all of you in this process. I did want to say, I think one misdemeanor in particular that I have a hard time like seeing being impacted by this is trespassing, because of the amount of houseless people that have no option but to trespass. Whether that's staying in a public park over the night or, being on a sidewalk. And I just don't think that, holding those people in jail or giving them electronic monitoring is going to stop them from something that they're doing because of their circumstances that they're in. So maybe if there's maybe if we're not, saying specific offenses that are going to that this is going to apply to, then maybe we can say certain offenses that this is not going to apply to. I know maybe not everyone will feel the same way, but it feels like difficult to punish people for something that they don't really have a choice in, especially if, it's in an area where there isn't a shelter or any place for them to stay. Yeah, that's just a concern of mine.
Thank you, and that's a worthy concern. At the same time, those are the store owners who are calling saying, this person's back in my doorway again because there might be heat coming up from the sidewalk there. So it's difficult. I think we have to ensure that where there are services available for people, shelters, et cetera, that they're made aware of it, and perhaps even given transportation there if possible, versus just cut loose again and saying, now don't trespass again. And I'm not without, although I wonder with winter coming if some of them aren't better off being able to have a place to stay than being sent back out into the cold. Representative Stone.
Thank you. One of the things that we always seem to forget to mention is the victims. And a lot of these crimes do have victims. Some of them do not, but a majority of them do. And we very rarely speak of victims in this committee. And one of the things we're trying to balance out, I think, is weighing out due process, presumption of innocence, while also respecting the victim's rights. Trespassing can have a victim or cannot have a victim. I think it's injurious if we decide to say, well, for trespassing, we're going to skip it altogether, but we're going to go to shoplifting, some other minor misdemeanor offenses. Misdemeanor offenses, felony offenses are classified for a reason. I don't think we should pick and choose which ones we're going to enforce, which ones we're not going to enforce.
No, I think that, first of all, to your first comment, the reason that we have narrowed it down to these things and we've said, okay, we have no tolerance on after your second arrest, and frankly, that you have a choice to wear the monitor or be incarcerated, is because of the victims. That's why we're doing this. And trespassing, as I said, with regard to the store owner, generally does have a victim, whether or not it impacts them. Someone who has a storage facility isn't as impacted as someone who's trying to run a business, but they're still a victim, and it's their privacy and their property. So I think that we're going to try to balance that. That's why I'm putting such an emphasis on making sure that people are connected with services at the time of the first arrest. So if they say, hey, I'm homeless, well, we have a shelter here that's available, and you can stay there, versus just saying, okay, we'll back outside, don't go back there again. But I agree about not picking offenses. Representative Reed.
Thank you. Society's always had the marginal people that struggled with things. It just seems to have exploded exponentially. So back in the day, we used to have higher standards, and people, you set the bar high, people will try to achieve it. You set limits, people will try, and I think we need to get back to that for public safety. We need to set the bar higher for people to meet, and not just, you know, give them a free run all the time.
I agree. And I'd agree wholeheartedly if we could reach into society and take all the fentanyl out. But until we can, we're not dealing with people who are able to set a higher standard for themselves because they're addicted.
And to
Sure, join the conversation.
to with apologies to Representative Rhodes. I always kind of seize up when we talk about the way things used to be. Crime rate in New Hampshire is significantly lower after bail reform than it was before bail reform. So I just want to put this in context. This is not a matter of this never seen before crime wave taking over New Hampshire because of bail reform. I know this committee by and large understands that, but I think the general public doesn't understand it. And I think what's good about where we are now is, in addition to crafting domestic violence laws and other laws that pay attention to the victims or the alleged victims in cases, we're also looking at the people in that second society that the chair refers to, who in many ways are as much victims as the victims of a specific crime in terms of the failures of society to create the set of social services that can address the issues. And you know, the challenge for this committee, which fortunately I don't have, but the challenge for this committee is to not impose too many of the imperfections of this two society world, not impose responsibility for those, too much of it, on criminal defendants, and make us feel better that we're dealing with a problem, but we're not actually dealing with those people. We're imposing things on them. So that's, you know, in deference to Representative Rose, I'll shut up now.
Thank you. Representative Wheeler.
Thank you, Mr. Chairman. I just wanted to say I'm surprised to hear you paraphrasing Martin Luther King and talking about two Americas, but it's true. There's America of wealth and prosperity and opportunity, and there's an America of living minute to minute and on the street and without. And I think that problem is much larger and much deeper than the New Hampshire Criminal Justice and Public Safety Committee can necessarily deal with. And as much as we, as legislators in a broader sense, should absolutely try to push for those more social services, I think what we can do in this committee is just ensure that the criminal justice system is actually a system and functions in a proper way. And I think the compromise of electronic monitoring in a constitutional way that appropriately addresses what we're seeing here in people being rearrested on bail without throwing them and locking away the key in the prison is an appropriate compromise. And I'm appreciative of your work and Representative Gothwright's work on this end and getting us to this point and emphasizing that we need, and Representative Rhodes. And getting us to this point, and I appreciate your emphasis on the social services as well. Because I think that's where we need to be going, and the Criminal Justice Committee, despite the fact that we can't deal with every issue, I think has done a really decent job in ensuring that we take a huge step forward in getting us to solving some of these issues. So I appreciate that.
Thank you. You should not be surprised. However, I have read Dr. King, and I have great respect for his work. I think that, you know, there's an old saying: when you're a hammer, everything is a nail. And we are a criminal justice committee, not a social services committee, and we are trying to deal with issues that really, a lot of them are social issues and not criminal justice issues. So we have to be very careful to try and not deal with social issues as crimes. So it's a very fine line we're walking to try and keep the public safe, ensure that victims of crime see justice, at the same time not punish people for the society that we created for them to live in. So we're working on it one day at a time. Representative Stone.
Thank you. One of the questions I have is, you bring up your data from 2018 and how we have reduction in crime. Does any of that studies indicate the deficiencies of law enforcement agencies that have been able to recruit, hire, and retain police officers? Obviously, less police officers means less on the road, less crime that they're actually arresting on.
The data I'm referring to is FBI data, which is accessible on Crime Data
Yeah, I'm
Explorer.
familiar. Thank you.
It doesn't reflect that. My experience in Portsmouth on the police commission is we are down at this point. We're slotted for 70 officers, budgeted for 70 officers. We last check we had 64, and we had a number in the hiring pipeline. The conversations I've had with the chief, the deputy chief, and the captains do not indicate that they're unable to investigate crimes or arrest people because of the 6 people who aren't there. It hasn't affected those kind of services. It affects other kinds of services. It means that the department is spending way more money, much to the displeasure of the city council, on overtime. So the shifts are being covered, the jobs are being done, but we're working our officers to the bone and they're doing overtime. That's the experience in Portsmouth. I can't speak for any other police department.
Representative Stone, though, I think that there probably is an aspect of that in other areas where there are significant staffing problems. That being said, I do think that what we are dealing with is not necessarily a statewide spike in crime, but a very focused area, in particularly highly populated areas where there are a need for services, and there's a lot of people that are reliant on public services, where you are seeing these spike in these nuisance crimes I'm talking about, with the trespassing, the shoplifting, the things of that nature. And that's why you're seeing actually the prime sponsor of the bill in the Senate was from Manchester. So I think that it's evident that while there may not be a spike in crime, there's a spike in the clash between the two societies I spoke of that needs addressing. And unfortunately, we won't be able to address it fully with criminal justice, because that's not what we should do. Representative Murray.
I don't want to start a whole back and forth on this, because I don't know, how productive it is, and I know we're all trying our best to come up with solutions here, but I'm really just stuck on this houseless people and the trespassing thing. Even if we made it like trespassing on public property instead of private property or something like that. But I think when we're talking about victims, like, these people are victims too. They're victims of society. I was lucky enough to buy my first house with my husband last year. And since that time, I've had 3 different friends stay with me because they became houseless, who had never experienced houselessness before, because the state of our economy is just crazy right now. People can't afford to live, and people who have never been in these situations before are now becoming houseless. And I think that's why we're seeing, an expanse in this area, if anything, is because people simply can't afford to live. So, for example, one of my friends had a child and was living in her car, to arrest her and, charge her with trespassing, put her on electronic monitoring, all this stuff. Like, how is that going to solve anything with a young mom trying to take care of her and her child? And I know we can't, as a committee, address all the social side and like services side of these things, but I also want to keep us from making the situation worse for some of these people. And I think we should try as hard as we can to like thread the needle and figure out, the issues where, like, shoplifting, there's a clear, victim that someone is being, harmed in that case. With trespassing, I know there definitely can be too, but I just think it's either not as severe or not like as often. Like in Manchester, it's often people staying in the park, and that's not harming anyone. And I also, am the rep here who lives in Manchester. I also work downtown in Manchester. I bartend at night. It's not a problem for me to come into my shift and be like, hey, persons, who spent the night in the doorway, please move. We're opening now. No big deal. Here's some water. Get on your way. At the end of the night, I give them leftover food, move on with my day. Like, I'm not a victim in that situation because best way they can get out of the cold is sleep in our doorway at night. And so I just really want us to think about how we cannot make the situation worse in the way we're trying to address this, despite the fact that we can't actually always provide the solution in this committee. And I know it's a tricky balance, but I'm just trying to bring that human-centered approach here as someone who has, again, a lot of friends who have become houseless over the past year.
Thank you. I think that's a very good point. Oh, and I was about to ask the captain, but he left. The number of arrests that are rearrests for trespassing. Did you want to add something?
Not to that point. Actually, something that's occurred to me as I've been sitting here, in terms of the legislation, I think that we talked about, or you've talked about, providing them with information about services. I think also, though, I think defendants are going to need to be provided with information about electronic monitoring before they make that decision. And
Yeah.
so I do think that should be part of the legislation, that they'll be required to be informed
I
of,
would think
what the
signed-
expectations are,
Yeah.
if there's potential costs associated. And then, I certainly agree with Professor Scher's thoughts about the availability of this data to law enforcement. And, if that's potentially going to be subject to a search warrant, which I don't agree with, but if that would happen, then I think they need to be notified of that before they make the decision. So
Yeah.
I think that should be required, that they are informed of those rights and sign off on it.
I agree that there will be some type of a form that says, if by accepting this, I understand A, B, C, D, D. And as I told the professor, I have no contemplation of putting in there that this is accessible by search warrants one way or the other. But like any data that's available anywhere, the police can apply for a search warrant. Whether or not the court grants it is a decision up to the court. But we could say we're going to bar it. But in that case, I could be causing another harm later, where it could end up being the key to a murder case that I don't want to get into that right now. And I would rather let the courts decide whether or not that's properly accessible or not.
Sure, but in terms of notification to the defendant,
Oh, yeah,
I
no.
think he would need to be notified that that's at least a potential,
Yeah.
before he agrees.
Yeah, I agree. Yeah. Okay. So at this point, I think we've discussed this enough, and I'm going to ask for, again, like I did yesterday, an informal vote so that we can send this language
May I address the committee?
very shortly. Yes.
Okay. First, Representative Pratt, when someone is arrested, they're giving, please stick around. I have a question for, you get something called What You Need to Know, and it lists the charge, your court date, court location, gives you information about a bail commissioner, and your right to an attorney. In addition, you're given a copy of the bail order, which is your legal promise to show up, your legal promise to abide by the conditions of bail, and it is your release document. Okay, so the people, when they leave, they'll sometimes ask, am I going to get a notification? Here it is. They are informed. It seems to me that we have this elaborate machinery that is unnecessary. Before I develop that point, there's a huge difference between electronic monitoring for misdemeanors and for an aggravated felonious assault. I think you need to separate. Here's why. This machinery sounds good. So did felonies first, and we know what happened to it. I live in the world. I don't see this particularly working. Where I'm going is right now I sign arrest warrants for people who bail jump. Okay. When do they get picked up? These people live in town. They live in neighboring communities. Some are in Methuen. We can't reach them. And the police sort of, they're loaded with work. They don't go after these people. The way they usually get pulled in is if they have they're caught speeding and they run the car. Then they see they've got a bail, then they bring them in. But it's, I can't say they never go to the house to get them, but it's exceptional. So what I'm saying, I believe this is a problem that needs to be handled at a higher level, mainly post-trial, not pre-trial. As important and essential as pre-trial is, I'm wholeheartedly for that, but I'm narrowing, and here's where I'm going with why I want to ask Professor Sheriff my understanding is correct. If you are arrested and on this, what you need to know, there's an RSA. I wish I had one with, it's in the car. It says if you're arrested on a second time when you're on bail, they don't need a bail commissioner. They didn't need, police have the unilateral right to take you to jail, period. And you see a judge. So my solution is, I don't understand. I don't see it in my jurisdiction, the jurisdiction in which I work, of this one after the other, after the other. I don't get that. I don't see it. And it's up the second time they go to jail, period.
Well,
And they
obviously,
see-
that's not correct. We heard the testimony from the Manchester Police Chief. We heard the testimony from several chiefs who said that they have a revolving door of people coming in, getting arrested, be released, arrested. So Salem may be different,
Oh.
but Manchester is certainly not.
I'm going to hold on. When this revolving door, it's not being done by bail commissioners. Why aren't they being seen by a judge and moved up in the process? There's something very loose about the way all of this is being portrayed. And I challenge you to think about this in revolving door. Who's doing this revolving door? Why don't they see it the second time? If I see somebody, if it's a completely different crime, which I almost never see, if it's the second time, I say, you don't have to call me. If you want me to come in, I could set a bail on this person. It's your option. But you don't, and the police know it. At least my police know they can go. So there's something very, how can I deny their experience? But there's something ill-defined, ill-administered here, because they should be before a judge, and maybe the judge is the revolving door. I don't know, but I see this as an elaborate machinery that's unnecessary, and that's where I am.
Thank you. To be clear, the statute allows for people to be released innumerable times on personal cognizance.
Well, I would.
Well, almost.
I wouldn't put it that way. The statute that's in place now, RSA 597-2, Roman numeral 3C, reads like this. If there is probable cause to believe, it's entitled failure of a person to abide by previous bail conditions. Getting arrested again is that failure. If there is probable cause to believe that, while on release pending resolution of a previous offense, the person committed a felony, a Class A misdemeanor, or driving or operating while impaired, there shall be a rebuttable presumption that the person will not abide by a condition that the person not commit a new offense. The court shall not impose a financial condition that will result in the pretrial detention of the person solely as a result of that financial condition, unless the court determines by clear and convincing evidence after a hearing that no reasonable alternative or combination of conditions will assure that the person will not commit a new offense.
So therein, I think, is the problem. Well, not the problem, but what the gap we're talking about is that all contemplates once you get to the judge. That does not contemplate what the bail commissioner should do. It says the court shall assume.
Well, my understanding of the bail commissioner statute, it gives the bail commissioner all the authority a judge has in terms of setting bail. So this applies to a bail commissioner. Now, in terms of improvement, then instead of saying the court shall not impose and talking about the court or bail, it could be more explicit, the court or bail commissioner, if we add magistrates to this, the court or bail commissioner or magistrate. That would make it more clear. And I think that's part of the issue with some bail commissioners in terms of training. I don't think there's a full appreciation of the scope of their powers. And that's a training issue, I think, that this committee has talked about.
Yeah. Okay, thank you. Okay, that concludes discussion. At this point, I would ask for a non-binding, just a vote to send this language over to OLS. Everyone in favor of the following: if someone is arrested while on bail the first time, they have an option to wear electronic monitoring, or they are held. On the second time they are arrested while on bail, they are held to see the judge. Could I see a hands of everyone in favor of that language, please? With the exception of possibly homeless people on certain properties. Thank you. And I think that was it, right? What do I feel like? That was it. Seems like we talked an awful lot about. Yes, sir.
One of the things I thought, did we agree, that one of the options also would be releasing someone under PR bail, with the pretrial intervention program being required as a bail, as a condition of bail?
We talked about it, but there was no pretrial intervention program available. That's the problem.
If available, where they are available, or?
I don't believe that we discussed it. Yeah, it would be the funding of that. Go ahead, Representative
I
Stump.
definitely think that would muddy the waters of what we're trying to accomplish here. You can't really mandate something that doesn't exist in a particular county.
We don't know exactly what services they have. I think that would be something properly addressed in the commission when they form the statewide. I don't see how we could.
Well, if you have a county, like Cheshire County, where they actually do have, pretty involved pretrial programs that are available. I mean, one of the ways we could write it is just say if available. So it would be an option if the programs are available. If they are not available, it wouldn't be an option.
What would be but I guess what I'm asking is what would be you'd have to be much more narrow. Okay, pretrial services, what will they contain? What?
This is in the situation, again, of, I know we're kind of combining things, but again, a nuisance arrest. So
Yeah.
you've got somebody who has an obvious problem, whether it's drug addiction, mental health issues, chronic homelessness, and they are arrested twice, let's say, for criminal trespassing or shouting at people on the street or whatever it is that they get arrested for. It would provide the option to divert them to some type of a program. If
I
it's
would
available.
agree that the court, we can say that the court has the option, but I want them to see the judge. So if the judge says, okay, you may be released if you go to pretrial services, that would be fine. But to put that on the bail commissioner and say, okay, you have to hook up with pretrial services somehow, there's too many moving parts that I can think of that how we would ensure that. It's Representative Stone.
Yeah, just a follow-up. If the individual declines to be released, that individual still has to be seen before a judge.
Yeah.
So it's not a long span of time. I
Oh,
would
yeah,
imagine
yeah.
it'd be 24 hours if they're held
Yeah.
in
No
preventive
one we're
detention.
talking about would be held longer than that short period of time anyway. So at which point the judge could say, I'm going to release you to pretrial services. We're not mandating the judge hold people, just the bail commissioner till they get to the judge, which can be no more than 24 hours.
So keeping it simple, I think, is the best way to go,
Yeah,
instead
I
of trying to add all this extra language and possibly programs that don't exist in certain areas.
Yeah, I just think that it's too much to happen in a short period of time until they're going to see the judge anyway, where the judge would actually send them to pretrial if it exists. Okay, but we're going to continue some of the discussions as we craft the language to send over to OLS. The next time we meet, we were going to have language on what we discussed yesterday and what we discussed today to have a formal vote of the subcommittee. And we will promptly move into the main meat of the matter with regard to the magistrate issue we've discussed and the crimes that the Senate wants included in how we are going to about addressing that. So next week is going to be very busy. We may have to add a day. I'm not sure yet. I know nobody likes that, but we're coming up on the deadline to get this stuff over to the clerk's office. So I'm not prepared to do any of that. But I am going to stay today just to type this and send it over to OLS, so that's going to be enough. Okay, yes, sir.
If we added a day, would that be Wednesday, do you think?
I'm not sure yet. Do you have a conflict?
Not necessarily, but as far back as we could know the day, that would
Yeah,
be great.
I'm probably going to end up
I'll
ending it.
probably be out of state on Monday. That's
I'm
my
probably going to end adding a day the following week as we come into the final week.
Okay.
Rather than next week. So, matter of fact, as everyone is available, I'm thinking about changing Thursday for Wednesday next week because I have another commitment for the legislature. Is anyone available next Wednesday or not available next Wednesday?
We do have another, we have the 470 subcommittee meeting at 10 o'clock on Wednesday.
How long does that usually last?
That's probably going to go about an hour and a half.
Okay, so I may end up having to move us to an afternoon on Wednesday, like a 1 o'clock.
Okay.
We'd only probably be meeting for an hour to vote on that. Friday would be longer though. I'll let you all know. Watch your emails. Okay. Anything else? Okay. Thank you. See you all next week.